So, good evening to everyone. Like the title said, this is about the first information report. Now, the interesting part, whether you're a lawyer, law student, somebody who has passion to learn or understand law, or who already has legal knowledge, it does not matter whether you fall into these categories or not. When the term FIR comes, one way or the other, everybody has heard this. Even the most of a layman, kabhi kabhi I have heard this thing when people have this heated argument, they very angrily spell the opposite party who has offended them कि मैं तेरे पे FIR करूँ. So this is the crux of this word first information. Now, why did I start with this introduction? Is because FIR, everybody knows, is something to set the criminal law in motion. Now, the legality of an FIR is because not every case that you file ends up being an FIR. So that is the major distinction under law, which talks about a cognizable offense and a non-cognizable. Simply put, cognizable offense has not been defined under the old law or the new law that has come into force. So a cognizable offense, in short, in 2C of CRPC says that any offense which is listed in the Schedule 1 of the CRPC, and 2G says under the Schedule 1 of the Bharatiya Nagarik Suraksha Sanhita. That is a new law which will come into effect in July. So at both places, what is a cognizable offense? It simply says an offense that is categorized in which a police officer can arrest without warrant and will be shown in the Schedule 1 of the CRPC currently and BNSS in the near future. So in such a situation where a case is listed under the Schedule 1, where a police officer can arrest without warrant, in such cases, it is mandatory to register an FIR. FIR is First Information Report. So FIR, like it said, the word also, from a common sense point of view also, it shows what? First Information Report. That means whenever an authority receives, an investigating authority, of course, which is the police in this case, whenever they receive the first information from somebody, the report that is taken down by them is the First Information Report. I think this clears out the question of what the basic understanding of FIR is. Now, what we need to understand is what is the effect of an FIR? How does it set the criminal law in motion? And how can somebody expect justice when they have approached the police station to register an FIR? Let's start with that. So, when an individual, first and foremost, it needs to be understood that under the old CRPC, it's 154 of CRPC, where the registration of FIR has been dealt with. Under the new law, I have to just check this. It is 173 of BNSS, which will come into effect from July 1. So far, if suppose today you go to the police station and register an FIR, it is going to be registered under the 154 of CRPC. Now, 154.1 of the CRPC says, whenever information about a cognizable offense is disclosed to an officer in charge or the duty officer for police station, orally or in written, he has to take it down in writing anyway. Once he takes it down in writing, the criminal law is set in motion, a copy of the FIR is given to the informant, and investigation in that particular case starts. That is how the criminal law starts. So if any offense has taken place, then it is mandatory as per this provision. That is cognizable offense. It is mandatory that an FIR has to be registered. I think that part is clear. Now, non-cognizable offense. If it is a non-cognizable offense, the police will have to take permission from the magistrate to investigate the case. So under the new law, it was, under the old law, CRPC, it is 155 of CRPC. That is investigation pertaining to a non-cognizable offense. So cases which don't fall under the cognizable offense, like I explained, which does not come under the Schedule 1 of the Criminal Procedure Code, those are categorized as non-cognizable offense. Non-cognizable offense, police cannot register an FIR. If they want to investigate a non-cognizable offense, they have to take permission from the jurisdictional magistrate under 155 of CRPC. And under the new law, it is 174 of BNSS. So that needs to be understood. So that is the case of non-cognizable offense. So whenever it is a cognizable offense, the police officer has to reduce it down into writing, and the FIR has come to be registered. Now, I will focus on the major aspect. I said that the moment the FIR is registered, investigation starts. So what when an FIR is not registered, and what is the law regarding inquiry? So this term is, I'm just going to give a basic coverage. it has to be detailed covered at a later point of stage. Maybe in future, if I get a chance, I will only cover it. Otherwise, you all can also look into this aspect. That is a difference between an investigation and an inquiry. Once an FIR is registered, it is always an investigation. But before an FIR is registered, or at any stage which is given, certain situations are explained under the CRPC, where an inquiry can be. So let's just say hypothetically, I go to my phone is misplaced. Okay, so my phone is misplaced. I go to the police station and I say, sir, I think my phone is stolen. Now it's misplaced. Of course, my phone had full battery, but suddenly it is coming switched off. So now I go to the duty officer of my jurisdictional police station. I tell him, sir, my phone is lost or phone is stolen, apparently. So stolen becomes an offense of theft, which is a cognizable offense under Schedule 1. So if stolen, if theft is a cognizable offense under the Schedule 1, of course, as per the law, what is the police officer supposed to do? He has to register an FIR because the cognizable offense is disclosed to him. But now, when the police, during the interrogation with me, when I go to give the complaint, he will ask me details when was the phone stolen, where was the phone stolen, what was the value of the phone. He will ask certain questions to understand the case. Let's just say, if he asks who stole your phone, and I'm giving a vague answer as such that, the last I saw my phone was in a particular mall while I was doing my shopping. And that is the last I saw my phone. So he will ask me, did you see somebody pick up the phone and stole it from you? So I will say, of course, I just could not find my phone. So he will ask me, how are you sure then that the phone has been stolen? This is where the ambiguity comes in. So basically, my version as an informant or as a complainant is that my phone is stolen. Whereas the police officer currently is inquiring into the matter. He's not investigating. He's inquiring to see whether there is a matter fit enough to be investigated. So that is, inquiry comes at the preliminary stage. So right now what the police is doing is, he is doing the preliminary inquiry. So he tells me that, sir, if your phone is in fact stolen, when we will do the inquiry, when we will check the CCTV footages or some surrounding witnesses, or when we trace your phone using telecommunication technology, then we can come to a conclusion that your phone is stolen. But till then, your phone could just be easily misplaced and you may find it under your bed tomorrow. We cannot be sure. So this particular stage, before the FIR is registered and where the complaint is given, that is where the aspect of inquiry comes. So the police officer is inquiring into the incident to see whether there is a cognizable offense or not. Because if it is simply misplaced, then the moment it is found, that part is solved. There's no question of FIR or a crime or an investigation involved. So this basic understanding of investigation and inquiry has to be. So now we all know what is the difference between investigation and inquiry. And an FIR will be registered if actually a cognizable offense is taken place. Now let me tell you one. In the same hypothetical situation, I tell the police officer that someone snatched the phone away from me. So there is absolutely no ambiguity. I saw the cognizable offense happen right in front of me. I am the direct affected victim. My phone was snatched from me. There is no question of doubt. So I tell the police officer, sir, this is not a case you need to inquire, but you rather can proceed with it because, simply put, I have seen the cognizable offense happening and my statement itself is a prima facie evidence for them to register the FIR because I have seen the crime myself. So 154 or the corresponding provision of 173 of BNSS both say that if an information of cognizable offense is given, they have to register the FIR. Now, there is two aspects when in 154, a minor change in the new law and the old law. So you need to know this. Any offense, even though it is cognizable, if it is punishable up to 7 years of imprisonment. Here, the police officer is given a discretion to either do a preliminary inquiry to see a cognizable offense is made or not, or directly proceed by registering an FIR once he is convinced that there is a prima facie offense. Now, what is the difference between 154 and 173? That is, where has a new law deviated from the old one? Is that under the old law, the concept of preliminary inquiry came in through the judgment of Lalita Kumari versus State of UP in 2013 by the Supreme Court of India. So where the Supreme Court said certain categories of offenses, which the informant will always say is a cognizable offense, but may not be. I'll give you some example. For example, some matrimonial dispute, case of medical negligence, corruption, or commercial dispute, which could be of civil nature, but somebody comes and tells the police, "Hey, I've been cheated of some finances." but it could just be a breach of contract. So certain cases which comes under these ambit, the Supreme Court has permitted a 14-day preliminary inquiry period to the police officer concerned before an FIR, if and when he deems it. If he knows a direct cognizable offense has been committed, no question arises of preliminary inquiry. But it was the Supreme Court which gave, through the judgment of Lalita Kumari, that the preliminary inquiry can be done by the police officer for a period of 14 days if the offenses come under these category and it is unclear to the police officer whether a prima facie cognizable offense has been committed or not. Very, very. Now, what is the difference? This concept of preliminary inquiry, which the Supreme Court brought in by the Lalita Kumari judgment, has actually been brought in by the Parliament. So the Parliament in 173 clearly mentions and gives power to the police officer directly by the statute, clearing all the ambiguity that a police officer, when an offense is punishable only up till 7 years, he can actually embark upon a preliminary inquiry. And there, the categories of offenses are not mentioned. The Supreme Court in Lalita Kumari had mentioned categories of offenses. But here, the Act does not mention certain categories, but gives a free hand to the police. If they are unconvinced, they can do a preliminary inquiry for a period of 14 and or they can proceed directly if a prima facie offense is disclosed and register the FIR. So a discretion is given to the police officer for preliminary inquiry by new statute under 170 of BNSS. So this aspect is also sorted. Now, since I've covered the aspect of preliminary inquiry and the investigation, now if you have an idea that what is the basic difference that surrounds a preliminary inquiry and what is the basic deviation under the new, that is 173 and 150. So now let's proceed. What happens? So once you set the criminal law in motion and a cognizable offense is disclosed to the police station, FIR is registered, then the investigation starts. And as per the old law, it is 173 of CRPC. And let me just check the new section. It's 193 of BNSS. So 173 talks about the final report. A final report is something that is submitted by the police after they have completed the investigation in the matter. So once the FIR comes into picture when you disclose a cognizable offense, investigation is done by the police. Then after the investigation is done, during the investigation as part of the FIR, what are they going to do? They're going to gather medical and forensic evidence. They're going to examine several witnesses under 167 of CRPC. Then they are going to draw panchnamas, that is spot panchnama, the Caesar panchnama if they see something. So and so on and so forth. Then once panchnamas, medical evidence, forensic evidence, witnesses are examined by the police, circumstances is evaluated. If there is any further cyber evidence required, that will be taken into account and everything will be compiled together. And under 173 or under the new law that is 193 of the BNSS, a charge sheet will be filed. Now, charge sheet is a colloquial term that we lawyers use. The Act uses the term final report. So, final is the conclusion of the investigation of the police into that particular FIR, which was filed before them. So, in that, I told you these are the categories of information that they will gather together against the particular accused person against whom the FIR was lodged. And this final report will be filed before the jurisdictional magistrate, who will deal with it in accordance with the law. So, after that, once the cognizance of the charge sheet is taken, the trial begins against a particular accused. So, I think this part is clear how an FIR eventually sets the criminal law in motion, gets the investigation done, gets the final report filed, and then the trial begins. So in order for a matter to reach the court, in case of a cognizable offense, it is important that an FIR is registered in the matter. So I think this part is understood. Now, in cases where an FIR is not registered, let's just say, I think this is somewhat you might have heard or even personally that police officers are not so keen on registering an FIR whenever you approach them for registering an FIR. There are two reasons mainly for this. First, the moment a FIR is registered, it has to be uploaded in the criminal tracking network system. That is a database which shows how much crime has taken place in that particular city. And then it is all compiled together to get a state statistics figure or a nation statistic figure into the aspect of how many FIRs have been registered. So when this aspect of FIR comes into, when the moment this particular, one second. So like I said, there were two reasons. So one was that the crime rate has to be shown in the national database the moment an FIR is registered and numbered. It has to be uploaded to the central servers. So then that particular FIR has been shown as a crime, which took place in that particular jurisdiction of the police. So now that we know that a crime has taken place, once you put the statistics together, if the police officers register too many FIRs, then it shows that they are not able to control the crime in that particular locality. Very second reason is they just do not want to do the work. Because like I said, once an FIR is registered, they have to investigate. Once they investigate, they have to do a lot of work like taking witness statements, obtaining forensic evidence, obtaining medical evidence, visiting hospital, and going to the spot to draw up a punch. So they have a lot of factors which get weighed in, and a lot of documentation work, and the time of the policeman concerned or the investigating officer is utilized heavily the moment an FIR comes into picture. So because of these two reasons, they will try their best to not register. This is more so in the case when the offense is not so heinous. Like it is my practical experience when my clients approach me through the police. When we approach the police for registering an FIR, they seldom do it when it is a case of cheating or something. They will simply tell Vakil sab aap to vakil or directly court mein case file. That's a general tendency because they think, oh, your client is rich, you're a lawyer, and there is a remedy to go file the thing in court. So therefore, I'll be coming to this aspect. These are remedies when FIR is not registered. So I'll come to that. So this practical experience, like I said, they will try to show you out if possible. Sometimes poor people are easily shooed away because they don't know the remedies or they cannot afford it. Or they try to solve the matter personally with their by calling the other party and telling them, and most of the people who are scared or poor will actually settle it then. So this is one aspect where without registering an FIR, police tries to solve the issue from a practical point. It is nowhere reflected in the law and the police does not have power for that. But this is what that happens free from my experience. Now, once this aspect of FIR is not entertained by the police, when you go to that, what can you do? That's a very important aspect. So when the police does not register an FIR, as per, I will just tell the section so that you all can take a note. That is the same section which under 154.1, I had told you all that the 154.1, that is subclause 1 of the section, talks about noting down the cognizable offense which is disclosed by the informer. In that same section, 154.3 gives a remedy for the concerned person to approach the superintendent of police. In a metropolitan city, it is usually the deputy commissioner of police, that is the DCP, who is an IPS officer. So if your jurisdictional station does not register the FIR, you can write a written complaint to the superintendent of police or the DCP of that particular zone, complaining about the fact that they have not registered an FIR, despite my case fitting into the bracket of a cognizable. Now, here in this case, the DCP will inquire into this. He can investigate it himself or direct the lower police station to register an FIR using his powers under this particular section. The same is there in 173 BNSS. This part is repeated. However, there's a very interesting catch. This also is a minor deviation compared to both the laws. Earlier, there were two remedies. Under the law, clearly written that either the station, you go and give a cognizable offense, or you go to the DCP and you complain about the FIR not being registered, and he intervenes and gets the FIR registered or not. Here is a third remedy, which 173 mandates, which was not mandatory before, but now the statute mandates it, that in case the DCP also refuses to register an FIR, then you have to approach the magistrate for a direction to get the FIR registered. So basically, the first remedy through court is suggested in section 173 of BNSS, which says that you have to approach the jurisdictional magistrate and file an application before him telling that the matter is not registered by the police. So you kindly intervene and give the direction to the police to register an FIR. Now, there's a slight deviation. Earlier, let me just confirm the section. Yeah, it is section 156 of CRPC, and the new section is 175 of BNSS. Now, this section had dealt with the police officer's power to investigate, and this had a subclause which empowered the jurisdictional magistrate to order an FIR if needed. Now, the only addition in the new law, that is BNSS, is that when the magistrate receives an application from a person concerned who is aggrieved with the police that they are not registering their FIR, that particular application first has to be annexed with an affidavit in support. So the person has to swear an affidavit that my complaint is true. That is first. Second, this deviation was not there in CRPC currently. That is, it says that the person who has approached the magistrate on this particular approach will send a notice to the concerned police station, will also hear the police officer of that concerned jurisdiction as to what he has to say about this particular aspect, as to why the FIR was. So a police officer will be heard, an affidavit has to be there, and the third requirement under the new law is that the magistrate is duty bound to do an inquiry. Now, as to what level of inquiry is not given under the Act, but the new law says that the magistrate, after looking at the affidavit, after getting the opinion of the police officer, third, he has to inquire, not investigate, but inquire. Again, the term inquiry is used. That is to make a good understanding as to what the case is about, whether he wishes to give that order to the concerned police station to register an FIR. So, three requirements under the new law when the police refuse to register an FIR and you directly approach the court for the registration. So, you have to make an application accompanied with an affidavit, and then the court will call upon the concerned police officer, hear him, and then will embark upon an own inquiry. And then finally, if the police magistrate is convinced, he will direct the concerned police station to register an FIR. So I think now the first remedy that is before you when the police does not register the FIR, I think is understood. That is approach the jurisdictional magistrate court appointing a lawyer. That is first. Now, let me tell you a very interesting aspect of a private complaint. Now, I'll tell the new section and the old section. The old section of CRPC was 190 and the new section is 210. So this is another alternative remedy. The first alternative remedy was asking the magistrate to direct the police officer to register the FIR. Second remedy is you can go directly to the court through your lawyer and file a private complaint, a private criminal complaint before the magistrate, which will be a document that contains all the evidence you have in your possession or whatever statements or affidavits that you would like to use in your support, and make a case directly before the magistrate. Like I told you, if suppose hypothetically I approach for a cheating case and I have all the document, bank account statements, transaction records, invoices or whatnot that supports my claim of cheating, why do I need to involve a police officer? So there are two aspects. Either the police officer refuses to register the FIR, or I just feel that I don't need the police officer. I don't need his investigative support. In these two scenarios, I can directly approach the court with whatever evidence I have, and I can make a case before the concerned magistrate, telling that, sir, you directly take cognizance of it. So it is as good as the charge sheet coming to the court. So basically, you don't want an investigation. This you already have the material to start the trial. So therefore, you approach the magistrate directly. So whether the police registers a FIR or not, you always have a discretion to approach the court directly. Under the new section, that is 210. Under the old section, that is 190 of CRPC. So this deals with private. The only change in the new law, that is BNSS, as per section 210, there is an addition that the person who can approach the magistrate to file the complaint, it can be a person authorized under special law. Now, who is a person authorized under special law? The one example that I could think of is like, if you have heard about the Domestic Violence Act, there is an officer called the Protection Officer, which is a statutory authority appointed for aiding the women who are looking to approach court or police when they are victims of domestic. So, if suppose I have to file a cognizable offense under 498A, that is domestic violence under IPC, if a person authorized under special law, that is his domestic violence, this protection officer, he can file an FIR on my behalf or a private complaint on mine. So therefore, the private complaint says in 210 that a person authorized under special. So a special functionary appointed by the government under some statute is authorized to go and file a private complaint on your behalf, whoever is the victim or the affected party. So that is a minor change. And that is section 190 and 190 of CRPC and 210 of BNSS, the corresponding. Now, I told you about how an investigation leads into a final report, that is charge sheet. Let's just say if during the investigation, the police officer does not find any against the concerned accused person or is unable to catch hold of the concerned. He is went absconding or he is no more there. So basically, he is unable to solve the crime. He has not apprehended the particular accused. So in such scenarios, there are three reports which are allowed under the Bombay Police rules, a police manual under the Maharashtra Police Act. So that is the A summary, B summary, and C summary report. So when it is not a charge sheet, you can find these three reports. What are the three reports? An A summary is when a case is genuine. The police officer believes that the case is genuine. Let's just see this mostly, and a good example that I can give is all those cyber criminals. For example, they hack your phone or morph your picture and they do it with sophisticated technology. Sometimes the police are unable to catch hold of. So the police know that the crime has happened. You have tendered evidence to that effect. They've investigated also. But if they are not able to apprehend the accused or find evidence against him, they will file an A summary report before the magistrate telling that, sorry, I'm unable to apprehend the accused or find enough evidence against him. But whenever I will find it, I will reopen the case and submit a charge. So that is called an A summary. Then there is a B summary. A B summary report is like when I filed a case knowing very well that that case is false, but I just wanted to trouble the other one. So during the investigation, in light of the evidence that the police uncovered during the investigation, the police can come to a fair conclusion that this was a false case. So therefore, the police can file a B summary report before the magistrate saying that my investigation revealed nothing and the person who is accused of this is innocent. So that is B summary. And C summary report is, for example, let's just say the police actually took my FIR when I went and told them that my phone was stolen. But in fact, it was just misplaced and I found it under my bed tomorrow. So in this case, my intention was not wrong. I actually believed genuinely that my phone was stolen. So therefore, I went and registered an FIR. Police also registered an FIR believing my story. Now they have come to realize that I found the phone under my bed. So now no offense has taken place. So if an offense has been registered and let's just say police has caught hold of somebody or they did not, they have to close the investigation. So they will file a C summary report. They will just tell the magistrate that this was by mistake. We investigated and there is no case made out. It was initiated by mistake. So therefore we are closing. So once the FIR is registered, 4 things can happen. An A summary report, B summary report, C summary report, or a charge sheet against the concerned accused person after gathering all the evidence. These are the 4 possible. So I think now that aspect is also covered. And in the remedies, I will tell you some remedies which are not directly highlighted in the CRPC or IPC, but I will directly tell you, of course, you can file a case against the police officer in the form of private complaint. That remedy is always there. But an easier approach, when you do not want to hire a lawyer, but you still want to give a tough fight, you can always approach the Maharashtra State Human Rights Commission, of course, if you are in the state, and you can also approach the Police Complaint Authority. Now, these 2 authorities are really good. And if you go, there is no format required, no lawyer required. You yourself can file a complaint and attend the hearings and make your case before the concerned commission. That is the State Human Rights Commission or the Police Complaint Authority. So you always can approach these particular authority, or you can just reach up to the higher ups of the police food chain. That is the commissioner or the additional commissioner. Sometimes it can be remedied then and there, but if you strongly feel that the police are being prejudicial towards you, there is some aspect of corruption involved, they are on purpose not taking your case or something like that, then you can always approach the State Human Rights Commission or the Police Complaint Authority or write to the higher ups. So this is the aspect of FIR, when FIR is not registered, and what are the remedies. Now, I think I've covered majorly everything. If you all have any questions, I think we can take up Q&A. Or is there something that you would like to add on? Somebody can tell me that, sir, please tell me about this, which is connected to the sector.
So meanwhile, Vinay, I'll take a few queries from the registration form. There was a query. Can you share a few recent landmark judgments
Few
on
recent
FIR?
landmark judgments on FIR. Aspect of FIR, like I told you. So one case, I will send since it's a written query, I can tell my office to send you the name of the judgment, but I'll tell you the crux, what the judgment says. First and foremost, it always mandates the magistrate concerned, if you're approaching under 156(3) or a private complaint, that not to go deep into the veracity of the witnesses. And because you are already coming to the magistrate because you have been shooed away by the police. So a magistrate must not embark on a detailed inquiry, but the moment he sees a prima facie offense, he is duty bound to register a private complaint or give a direction to register the FIR. So this has been covered by a plethora of judgments of the High Court and the Supreme Court, 2 or 3 which are very recent and which is in the highlight. I will send it. And then, of course, Lalita Kumari is one of very important aspects. Though the new law has come into force, does not mean that Lalita Kumari has been completely brushed aside. Lalita Kumari and the new law are on the same page, that if a cognizable offense is disclosed and the police know that it is a cognizable offense, they have to register an FIR. So I don't think so there is anything that has come new, because this is something that everybody has accepted. It's the same case that will keep on being repeated, and the same judgments are quoted in the new judgments that have just come.
So any online system of registering complaint?
Oh yeah, thank you for bringing that up. In the new code, there is an aspect which is an addition that electronic FIR can also be registered. So this is a new addition. But somewhere down the line, I'm not so satisfied with this. Though it's a step in the right direction, still, I'm not so convinced, because it says if once you give an eFIR, that is electronic evidence, of course, through a phone or through a video conference, you can register an FIR. But the section says that within 3 days, that the person who gave that FIR through electronic medium must go and sign. So then that defeats the purpose of that electronic evidence. So if so-and-so evidence is taken by the police, and in 3 days you anyway have to come and register the FIR and give a signature of yourself personally, then that defeats the purpose of electronic. And even if, let's just say, we approach, of course, the portal is there, that every state has its own police portal. So you can go there and register an FIR. But actually, when you register that, it does not immediately become an FIR. It goes to the jurisdiction, it gets sent to the concerned jurisdictional police station. You will receive a call from there, and then you'll have to go there and register an FIR. So though online remedies are there, it has not fruitified into an aspect where it is very convenient for us citizens that we don't have to visit, but everything gets done. It is not so like that. You still have to visit the police station, give your personal signature, and then get the things.
So instead of a signature, any email confirmation or digital signature that works too?
No, I mean you have to go. It has to be taken.
Oh.
Let me just check the exact word. It says immediately that the police officer has to take the signature. So police officer has to take the signature. I mean, digital signature is not something that is frequently encouraged. I have never seen a case where somebody has given a digital signature to the police officer and police officer have accepted. I have seen situations where even a power of attorney holder is also not entertained by the police officer. They always insist that the victim herself or himself should. Even when it comes to the informant, sir, I have faced situations where, for example, 154 or the new provision of the new BNSS both say that any person can be an informant. Let's just say crime has happened to you, but I'm your lawyer and I go and inform that something has happened to my client. Ideally, as per law, they are supposed to register the FIR with my signature because I have given the information and I'm aware of it. So he has to set the criminal law in motion and he can take your signature or statement later. But what happens is when I go and tell that the crime has happened to you, he will or she will insist that you come personally to register the. So this is some area where we don't get into a quarrel with the police because we think if it is just the person who's affected needs to come, then they come. But in situations like that, when there is a burn injury or an acid attack or somebody is hospitalized due to an accident or something, then I have seen the police officer go to the concerned police hospital to take their statement and register the. So this exception I have seen. But otherwise, in our ordinary circumstances, I have never seen a police officer being okay with a digital signature. First of all, they are not even educated on these aspects of electronic. They just know the basics of it. So most of the police officers are not trained to handle electronic devices or familiar with electronic devices. So they literally struggle to do that. They basically have some officer or some technician or somebody to help them with even the current basic systems of uploading the FIR or something. That is my practical experience.
Okay, thank you, sir.
Meanwhile, Vinay, there's one question on the chat. The next participant is unmuting. What are the provisions for amending the information provided in an FIR?
So a supplementary statement is taken. So let's just say you miss out on some details and then later on you realize. So even the Supreme Court and the High Courts have always reiterated that an FIR statement is not an encyclopedia. It does not include anything and everything. Of course, what comes to your mind at that point of time when you register the FIR, you will tell that to the police officer. But let's just say you missed out some important detail, but later on you think, or the police officer himself feels there is no clarity on a particular part of the statement that you give. So you always can give a supplementary statement. So when a supplementary statement is taken, it's as good as a main statement taken in the FIR, and both are annexed together and both are made part of the charge sheet. So there you don't need to worry that you did not say something in the FIR, but you recollect later. There is always a provision to go to the police officer and give a supplementary statement.
Yeah, good evening, sir. I'm Aarti Agar. Sir, see, I have given to police n number of time under CRPC 154.1 to register information because being an animal activist, they don't take complaints. Being a tree activist, they don't take complaints, though it's a cognizable offense. And अगर under pressure में वो FIR ले भी लेते हैं सर, तो उसको चार्ज शीट में नहीं बदलते हैं.
हाँ, समझ गए, बराबर. Because mostly क्या होता है ना मैम?
ऐसी सिचुएशन में सर व्हाट टू डू, बिकॉज अभी मेरा तीसरा केस भी आ रहा है.
अच्छा, आपने जो कंसर्न डीसीपी है आपका जुरिस्डिक्शन का, जो जोन का है, आपने उनको कभी अप्रोच करके देखा?
यस सर, सब अप्रोच कर लिया है, सब मुंह पे मीठे मीठे और बाद में गायब. दे डोंट इवन रिप्लाई टू आरटीआई.
Then I think ma'am it is a fit case where you should involve the State Human Rights Commission or the Police Complaint Authority. You can find the details online, very easily accessible. You write a complaint against the senior police inspector of your concerned police station and the duty officer whom you are frequently meeting or filing the complaint before. Make a complaint. Let them know that you are going to take this seriously, because once a complaint is made before these commissions, the hearings take place quite good. The rate is also fine. I mean, the rate on which the hearings take place is very good because I have some personal experience there. So you can always make a complaint before the Human Rights Commission or before the Police Complaint Authority. Or have you tried reaching above the DCP, like maybe the additional commissioner or the commissioner?
I have sent it to CP sir also, CM sir also कि भैया यहाँ पे ये कहानी चल रही है.
नहीं, what happens तो मैम क्या हो जाता है, आप अगर बस लिख के भेजोगे ना, हमारे देश में कोई कुछ करता नहीं. Let me be very frank. आप एक चिट्ठी लिख के आपने किसी को डिस्पैच कर दिया, हार्डली मेरे को कोई पता भी नहीं कि वो पढ़ता भी होगा कि नहीं. Even if they inward it, I don't think so they will give the seriousness. So once you write a letter, sometimes in my office we have a practice. I send a junior to deliver it by hand. So he takes my letter on the letterhead, goes to the senior PI, gives it in his hand, and demands an acknowledgement. So वहाँ पे at least you can be sure that somebody has personally known about your case, is aware about your complaint, and is forced to read it. So you can expect a little better result when you hand deliver it to the concerned person. So if you have written an email to the commissioner, always make it a point to go and visit him during the visiting hours. It's your right to go and visit these public servants, and they are supposed to entertain you. After all, they sit for our assistance.
Right, sir. It has been a very bad experience. Senior
If that is the case, if you're tired of the system and you are tired of all those officers and the superiors, I would strongly recommend them go ahead with the State Human Rights Commission or the Police Complaint Authority. Make all these officers party them. Let all of them be summoned.
And I am sending it to registered AD. Up, sir, to further this, अगर FIR के ये लोग charge sheet file नहीं करते, जैसे there was an assault on me and my husband for taking care of the cat. Police refused to file FIR. So the video was there and we called the police immediately 112. They made me sit in the police station in the night from 12:30 a.m. to 4:30 p.m.
Did they force you to do that, ma'am? Did they force you like you cannot get up from here? Or they asked you to do it? There are two situations here.
आप पुलिस स्टेशन आके FIR कराओ. अरे मैंने बोला इधर असॉल्ट है, विक्टिम घर में बैठा था, मुझे बिठा के रख रहे रात भर.
नहीं तो आपको बैठने का जरूरत नहीं था. आपको रात को पुलिस स्टेशन में बैठने का कोई जरूरत नहीं है. आप हमेशा उठ के निकल सकते थे और आप ड्यूरिंग द डे आके सीनियर पुलिस इंस्पेक्टर से मिल सकते हैं. एंड इफ योर एक्सपीरियंस लाइक आई सेड इज सो बैड विद द कंसर्न पुलिस स्टेशन ऑफ योर jurisdiction, please approach the State Human Rights Commission and the Police Complaint Authority. There is no point just writing to the higher ups. And अगर आपने commissioner, additional commissioner या DCP को लिखा है, तो please make all of them a party in your complaint before the commission or the police complaint authority. उनको आने दो, तो उनको समझ जाएगा. They are duty bound to respond to that complaint before the concerned body. So, and I have very good experience there. So they will take appropriate action and they will tell them why in your case consistently they have defaulted on registering an FIR. And they have treated you disrespect. So all this जो आपको रात को बिठा के रखा, आपको रात को बुलाया और बिल्कुल हीट नहीं दिया, everything kindly mention in the complaint that you make before these authorities. I think you should get some good result.
I will, sir. And secondly, I want to know, आप जो FIR का बोल रहे हैं, अब इसमें क्या हो जाता है सर, जैसे पब्लिक सर्वेंट होता है, उसके खिलाफ पहले तो आपको एक प्रोविजन है कि डीम कंसेंट लो सबसे FIR फाइल करने के लिए. फॉर एग्जाम्पल जैसे मुझे डेप्यूटी रजिस्ट्रार के वेस्ट वार्ड के खिलाफ for his misconduct FIR फाइल करनी जो उसने मेरे साथ किया in the hearing and not going.
Are you talking about the requirement of a sanction?
Yes. So sir, is it required or I can directly go under?
So basically, not everybody is protected by a sanction. Of course, certain higher officers in the government are always protected by sanction. And I will see it's a very tricky area for me to get into and say whether sanction is required or not. But obtaining sanction is actually the police officer's job. You don't have to go to the government and ask them to give a sanction. Your duty is only to approach the police officer. Where they take advantage is this. They make it look like getting the sanction is so difficult that we don't want to go there. And they put it on you. But that is not the rightful way. So if there is a sanction required also under the law, once you make a case to the police officer and tell them that whatever that particular concerned officer has acted not in the official capacity, but has deviated from his official capacity and has done a crime. So for example, he cannot say that I took money from somebody and therefore I passed a particular order. Of course, that's not in discharge of his duties. That's not his official function to actually favor any party. So of course, he's deviated from his official function and has done cause prejudice to him. So in such a scenario, he has committed an offense under the Prevention of Corruption Act and other provisions of the IPC. So now you go to the police officer and make this case before him. अभी ये case बन गया, तो ये police officer की जिम्मेदारी है after his investigation to obtain the rightful sanction. तो sanction लेने के लिए it is like a charge sheet you file first before the concerned department of the government and tell, see, so and so material is gathered by me against so and so person who is a public servant under you, who's a senior officer. So kindly give me the sanction because I have all the material to prosecute. So once this is done, they give the sanction and the police officer argues the case that I have obtained the sanction. It is not your job. So ideally, your duty is only to disclose the cognizable offense. It is his duty to set this all document in order. That is his job, not your job.
पब्लिक सर्वेंट के लिए IPC 166 and 217 लगता है जो मैंने दुनिया से पूछ के किया है. So अगर मैं registered AD के through if I send, is it okay? And then I put an RTI where why you're not filing.
No problem. Yeah. So like I told you, I suggested you go and deliver it by hand, or after your post reaches the police station, you go and meet the duty officer. So and so complaint was received by your station on so and so date. ये मैं क्यों बोल रहा हूँ? Once you go and alert them कि I made so and so complaint, When you file a complaint against these police officers for their inaction, you will get one more point to add before these authorities that I personally visited and reminded them also. Because Varna, you know what their first defense before the State Human Rights Commission or Complaint Authority would be, कि for some reason and due to somebody's fault, whoever took the letter, ये letter हमारे पास पहुंचा है. अगर ऐसे बोलेंगे तो, they will look negligent but not prejudicial. So they saved themselves by using this tactic. Therefore, I said, you have to personally ensure whether they have read your complaint. This is just a further safeguard. Of course, you can just post the letter and then approach these commissions and make a case. But they will get away easy if you just post a letter and not follow up with it. So that's my advice to
you. Thank you, sir, for answering so many queries in such a
no problem. I wish you all the best, and I really am glad that you are standing up for animal rights and you're doing your bit to stand up for the things that cannot speak for themselves. So I'm very honored by what you're doing. So please continue the good work. And if my office could be of any assistance, you can reach my team.
Please, sir, because I've been assaulted and I've been get out by police not to protect the trees and confined in my home. A lot of things are happening,
I get that.
Thank you.
Not only to you, it is happening to a lot of people across the nation. So I understand what you're doing.
Hello. First of all, I would like to thank PLEA and Vinay sir for conducting the session. And my query is that I have many clients who are victims to cybercrime. And there are many scams going on where they are asking for money and this and that.
Right.
My query is that when we go for an FIR, they just give us a normal sheet of paper where the complaint has been written. But whenever we go for follow-ups, it's been like 2 months, 3 months with one client of mine and 1 month for the other client. And when we go for follow-ups, they're like, hum log follow-up kar rahe hain. Now, my question is that what is the remedy? Should we go the same procedure, what you just mentioned in
Ma'am, a very good question. मैं सच बोलूं ना मैम, मैं खुद तंग. You need to understand. So we all are on the same page here. Despite being an advocate, having all the resources at my hand to follow all the procedures that I just gave in the lecture and by answering the Q&A, spam calls are like an everyday routine for every one of us. I think दिन में मुझे तो 3 कॉल आते हैं. कोई तो credit card department से, कोई false person who asks for my CVV or credit card number. Now this has become very big routine. I think if you are following the news, I think in Cambodia, 5,000 Indian citizens are forced to scam us only. This came up in the newspaper very recently, and our Ministry of External Affairs is trying to rescue those people. So there are all kinds of people involved in the scam business. Now, what is happening is there is an overload of cases. Like Gandhi ji ने independence के time में जेल भरो आंदोलन किया था. जब आप अगर सब लोग क्राइम करने के लिए निकलते हैं और सबको आप जेल में डालोगे, एक पॉइंट तो ऐसा आएगा ना कि एक्चुअली जेल्स ही फुल हो जाएंगे. सो नाउ द पॉइंट इज पुलिस का आई टेल यू आई एम नॉट सपोर्टिंग देम और आई एम सेइंग दे आर राइट, बट आई थिंक देयर हैंड्स हैव गॉट टू फुल बिकॉज अगर मैं आज जाके कंप्लेंट करूंगा दैट समबडी अटेम्प्टेड टू स्कैम मी, मेरे ही आज 3 FIR हो जाए. सो नाउ द क्वेश्चन इज व्हाट वी नीड इज टेक्नोलॉजिकल एडवांस. सो आई थिंक द टेलीकॉम रेगुलेटरी अथॉरिटी ऑफ इंडिया, and also I will get back to you on this because I will need the site details, but there is a particular number where you can report the spam calls. So at least what they are trying to do is they are either deactivating it or some authority is specifically tasked for this is trying to trace them. Now in certain cases where you have lost the money, मतलब आपका अगर पैसे गया है तो directly FIR बनता ही बन, वो तो offense बन ही गया. But I'm talking more about the cases where attempts are made to call you and scam.
No. So my clients have been scammed by money. So I'll just
FIR बनता है, वो FIR बनता है, तो definitely बनता है. अगर आपके जेब से 1 रुपया गया है, first of all, let me tell you one thing. The moment you lose money, as per the RBI policy, that is the Reserve Bank of India, आप अगर 3 दिन में आपके बैंक को inform करते हो, I'm telling you as a remedy for your clients. Because police वाला, of course, you always have a remedy. But just for their own safety, a proactive measure, so that they get some relief immediate. This is that you immediately call on the banks now because it is mandated by RBI कि अगर आप 3 दिन के अंदर, whenever that financial fraud has happened to you, अगर आपने आपके बैंक को inform किया कि so and so amount is debited or fraudulently taken from you, then the bank is supposed to give you that. So you lost nothing. See, that's an immediate remedy. I think this is a solution that the RBI came up with because everybody is going through this a lot and the police is unable to handle the overload of cases because these scamsters are so technologically advanced that our current police technology is not good enough to trace them.
Absolutely.
That's the hard reality.
Yeah. So coming back to my question, so so we have done all this for my recent client जिसका 1 महीने से हम लोग follow up कर रहे हैं, but the police has been unable to trace where the money has flown because बैंक से वो लोग ने UPI में किया and immediately the UPI में से it was the money was distributed to 3-4 people. So my question
one thing
again.
that you can do is, ma'am, see, one thing you can do is, in case if you feel that the police are not doing it, like whoever is the concerned local police station, who is the investigating officer in your case, you can always approach the High Court for change of investigating authority. So, so I'll tell you something. Whenever we go with an offense to a particular jurisdictional police station, we register the FIR. The police officers who actually investigate our case are already overburdened with all the bandobast, other cases, because already it's heavily outnumbered. Matlab, the police officers are very less compared to the number of cases that get registered. So a single police officer may have hundreds of cases to investigate. So his investigative prerogative or his involvement in the case may be very less. So in such scenario, the dedicated investigation branch, which is the crime branch or the CID, is a very useful tool because they are at liberty to pursue a case more freely. They do not have bandobast or the other law and order requirements that is warranted from them under ordinary police jurisdiction. So you can always approach the High Court for change of investigation authority. So from a local police station, you can always get the investigation transferred to crime branch. But after all, let me tell you very frankly, if the crime branch also fails, of course, you can approach the CBI also using the High Court. But if you know that they are very sophisticated and it is just not impossible for the investigating authorities to track them, then it's a lost cause. Unfortunately, those people have got away with it. There are many cases in our country where criminals have been so sophisticated and good that it is difficult to trace. It's impossible to trace them. And we have live cases where our investigating officers are unable to do anything to people who have absconded our nation. They live in other nations very happily, very luxuriously. Are we able to do something to them? We have been trying procedure and again. So therefore, the new act, one good thing that came in the new law is that there is the concept of trial in absentia. Even if they are not there, trial can be conducted against them. Once they are convicted, then they are convicted felons, no matter which country they are. Our country has convicted them with due process of law. So then a lot of laws will happen. So this is a good step in the right direction. But like I told you, if it is not possible for the investigating authorities to actually investigate well, then it is a problem. Then we have reached a dead end. So that's the unfortunate scenario in some cases.
I understand. Yeah. Thank you for your time.
Welcome, ma'am.
Sir, I have one question, sir. Sir, when this provision of electronic FIR will be implemented, so I think they are going to implement through ICJs, that is Integrated Criminal Justice System, by which all police station courts and these jails and all.
I think they are working hard on some central system because that is why they have taken a lot of time for its implementation. If you see, the assent of the president was received in December, but in July it is going to come in force.
Yes, and that will come into force on 1st July. So I think there is also a risk of false FIRs being lodged. So I think
very so therefore I told you, no, sir, there is an aspect of preliminary inquiry. That is why I said that
now that is introduced preliminary inquiry there, and further when one say files FIR under this BNSS 173. So I think people should be made aware by displaying warnings on the website, such as provisions like IPC 182, because it is very difficult for police to change the sides, because then the accused becomes criminal, the accused becomes victim becomes accused. So in one way, it is very difficult.
Okay, so if you see, sir, the question that you asked is actually of great essence. Because अगर कोई किसी के पास डर नहीं है false FIR करने का, तो false FIR बढ़ेंगे and they will do it with complete impunity. कि कुछ होने तो वाला नहीं है. But sir, unfortunately क्या है, आप कितना भी लोग को educate करोगे, पुलिस खुद action लेता ही नहीं. ये जो 182 और 211 आपने बोला, people don't do police officers, they even if they themselves realize कि FIR false है, they don't actually go and take action against somebody under 182 or 211. I will tell you frankly. जरा सोचिए कि एक दिन में अगर 10 FIR रजिस्टर होता है, उसमें से 5 अगर फॉल्स थे, तो ये जो पुलिस ऑफिसर है या जो सीनियर पुलिस इंस्पेक्टर है वो स्टेशन का, उसको 5 नए केस इनिशिएट करने पड़ेंगे बिकॉज those cases are false. तो basically, like I told you, it's a question of convenience. So mostly they ask the party only to go and file a private complaint or file an FIR further because they do not want to set a precedent कि हम खुद ही action लें. Now this is very unfortunate. Actually, the law should make it mandatory that upon investigation, अगर वो C summary या कोई और B summary file कर रहे, वो खुद के investigation में they reach a conclusion कि it is a false case, The law should make it mandatory for them to initiate counter action against the person who made such a false. I think,
Yes,
sir,
sir.
displaying that will not solve the issue, but the law which mandates the police officers or makes
Yes.
a specific authority like independent of this, ताकि police officer के सर पे burden ना आए, but एक independent monitoring authority जहाँ पे आप बस उनको intimate कर दो कि ये से ये charge sheet या ये B-summary report में clear case made out हुआ है कि ये false case है, तो आप necessary action लीजिए. अगर ये एक बार implement हो गया, then I think, sir, it will solve a lot of false FIRs का problem. This false
sir.
criminal proceeding का issue, is actually plugged the entire justice system because high court में भी caution के cases बहुत बढ़ जाते हैं, lower court में भी discharge के cases बहुत बढ़ जाते हैं. So basically, a lot of matters and judicial time is wasted because of false FIR. And people against whom false FIRs is lodged, I have my own many clients who go through this particular problem. जिनके खिलाफ false molestation case या rape case या domestic violence case फाइल हुए and innocent है, पुलिस को खुद पता है, बट फिर दूसरे पार्टी के खिलाफ जब तक एक्शन लेते हैं या तो बहुत टाइम जाता है या तो बहुत लॉयर पे खर्चा करना पड़ता है या फिर कभी होता ही नहीं.
हाँ, तो सर आम पब्लिक को ये पता नहीं होता है कि FIR केस और कंप्लेंट केस में क्या फर्क है, तो फिर ये कि दे डोंट रियली से are not aware of say any difference between cognizable and non cognizable. आम पब्लिक को तो ये पता है कि अपराध हुआ है तो थाने में जाके रिपोर्ट लिखानी है, फिर पुलिस बताती भी नहीं है कि जो
मेरे बहुत सारे क्लाइंट सर यही बोलते हैं कि हमने पुलिस स्टेशन में कंप्लेंट तो किया, बट दे डोंट नो ना FIR रजिस्टर हुआ है कि नहीं, उनको पता ही नहीं.
हाँ,
70% of the people don't know कि FIR is necessary also. So that is true, but so unfortunate, no sir. We all have to collectively think about it. And so it's a question of awareness. So who is to blame in this? Because the law is there. I think we need to ensure that वो जो basic civics होता है ना हमारे स्कूल में, I think ये सबको पढ़ाया जाना चाहिए कि ये जो basics of FIR should be at least included in 9th and 10th standard, so that everybody at a young age is also, educated about this fact कि how to visit a police station and how to file a complaint. I think ये बहुत rudimentary. अगर वैसे आप स्कूल में एक बार पढ़ा दोगे,
नहीं किया गया. Yes, I think that was the reason.
That's the best way. अगर आप स्कूल में पढ़ोगे ना, जैसे हम लोग को civics में पता है कि प्रधानमंत्री कैसे बनते हैं, प्रेसिडेंट कैसे बनते हैं, कैसे बनते हैं, बट हम लोगों को कभी ये जो बेसिक चीज है कि पुलिस कंप्लेंट कैसे फाइल करते हैं ये पता ही होना चाहिए. एंड आई ऑल्सो रिमेम्बर हम लोग को चिट्ठी कैसे पोस्ट करना है, इनलाइन लेटर क्या होता है, ये सब तो हमारे सिलेबस में वैसे भी. तो दिस इज शुड नॉट बी अ लॉ ओरिएंटेड सिलेबस, बट इट शुड बी अ जनरल सिलेबस. एवरीबडी शुड हैव अ चैप्टर एट 9th or 10th standard or in the 11th or 12th. बेसिक एजुकेशन में ये बनाना बहुत जरूरी है. फिर जो आपने ये अवेयरनेस का कंसर्न बताया ना, ये तो हमेशा चला जाए.
जी सर, थैंक यू सर. जी सर,
वेलकम.
Thank you.
Okay, Vinay, there are a few queries on the chat box. Is there any time limit for filing FIR on occurrence of the event?
So I'll tell you something. Delay in FIR, there is a limitation under the CRPC that when the cases are not punishable more than 3 years, you have to file the FIR within 3 years. So 3 years is the limitation prescribed under the criminal law. But this is only in cases of those where the punishment is up to 2 or 3 years. If it is serious or grave issue, like you might have heard about the Me Too movement and all. So if somebody has been sexually assaulted, let's just say 20 years back, उनका रेप हुआ, the rape हुआ था करके ये जो fact है ये undisputed, ये हुआ है. So if you go and tell the police officer today that I was raped 20 years back, of course this raises serious questions about the genuinity of the case. So I'll come back to that later. But अगर समझ लो कि रेप हुआ था, किसी के पास वीडियो एविडेंस है या CCTV फुटेज है या फिर कोई विटनेस है जिसने रेप होते हुए देखा या जिसको पता था, या कोई मेडिकल एविडेंस है टू शो दैट there is rape. तो अभी अगर evidence है and then there is a good case that you have, but you have just not raised it at the right time, then of course FIR has to be registered. Abhi question is how good that investigation will take place or how genuine the case would be and whether the case will stand the test of trial is something that we'll have to see later. So FIR के लिए कोई limitation नहीं है apart from the categories that I told you, which is punishable up to 3 years. उतना तक का FIR में 3 years का limitation, बट उसके बाद का उसके ऊपर के सजे वाले कोई भी, इट्स वेरी प्रैक्टिकल टू अंडरस्टैंड. नो, आज मेरा मर्डर हो गया, 20 साल बाद मेरा डेड बॉडी मिलता है, सबको लगा था मैं मिसिंग हूँ 20 साल से, बट द मोमेंट माय डेड बॉडी इज फाउंड देयर हैज टू बी अ केस ऑफ मर्डर रजिस्टर्ड, है ना. सो FIR इज पॉसिबल, क्रिमिनल लॉ कैन बी सेट इन मोशन. द क्वेश्चन इज अबाउट हाउ गुड द केस वुड बी आफ्टर सच अ लॉन्ग डिले, दैट द प्रोसिक्यूशन विल हैव टू एक्सप्लेन कि डिले क्यों हुआ.
Okay, Sundarasan sir is asking, is there validity of FIR and is it worth waiting for the justice?
Is the validity of what? So sorry.
Is there a validity of FIR and is it worth waiting for justice?
I mean, this is a very philosophical question. If somebody has wronged you in a very, if you just see in a mythological sense, you want to leave it to karma. and forget it, that also is possible. And I can bet this, we all human beings at one point of time might have forgiven somebody or might have left it to karma. So now the question is, what kind of situation are you in? What is your ability to fight? What is it that you're looking for? Is it revenge or is it justice? And whether it is valid or not or worth waiting actually is a question that you have to answer yourself. And depending on the crime and the person, let's just say somebody cheated me and took some money, but I know that that person cheated me and took that money because he's in a very bad situation and I know him very personally. Now I am at liberty to go file a cheating case against him. Maybe I'll get justice also. He will be put behind bars. But on the other hand, I think that he's apologetic and he actually has a change of heart and he stole it based on necessity. If I forgive him, there is no question of FIR or criminal proceeding. And high courts generally quash cases also when parties arrive settled. So the question is, वो जो ये आपको personally answer करना है कि whether that fight is something that you're seeking. कभी-कभी कैसा हो जाता है, you're wronged too heavily and you have the means to fight. You are assisted by a good lawyer. You have money, everything you have. Then the question is, it's okay, na? You file an FIR. No? Because ultimately, you have done something. What is taught to us since childhood by our parents or by anybody? कि आपके हाथ में जो है आप कीजिए, फिर जो दूसरे के हाथ में या भगवान के हाथ में है वो तय करेंगे. बट अगर आपने आपका पार्ट नहीं किया तो फिर आप सामने वाले से क्या ही एक्सपेक्टेशन? बिकॉज आई हैव फेस्ड गुड जजेस who actually dispose of matters very quickly. I have had back-to-back hearings in the magistrate court or in the high court, or where the matter is kept high on board or kept fixed. So if your matter ends up before the right judge, ends up before a right police officer, and your lawyer is good, don't you think you have a very good fighting chance? Then why would you think like, oh, it is not worth the wait? So it's a personal call. I would leave it to you.
Okay. Can a FIR be filed without the informant signing the FIR?
Can.
Can a FIR be filed without the informant's signature?
So that is what I'm trying to tell you. As per the law, FIR can be filed by anybody who has knowledge of the incidents. For example, I saw murder happening with somebody on the road. Now, the actual victim is the person who died, or let's just say who was assaulted or who was molested. I saw a lady getting molested. So that is a better example. Now, the victim and the informant ideally should be that lady. But I, as a responsible citizen, decided to go and inform the police that a cognizable offense is taking place on the road where I was passing by and kindly register an FIR. Now, as per the law, they are mandated to register the FIR. And whoever the victim or the informant is, who's directly affected by the crime, their statements can be taken later on at the stage of investigation. Of course, their evidence is very vital because that wrong has happened to them. So, without their statement, the case will not stand because who else has the case? But to set the criminal law in motion or to register an FIR, anybody is, but anybody who has knowledge of it, there should be some level of info. Then that person can go and register an FIR.
So you're referring to some visiting hours to meet the commissioner. Are there some visiting hours, irrespective of the matter?
Yeah, I think these officers have a visiting hours. You have to personally confirm. It depends on which officer you want to meet. So everybody has to have an official visiting hours. Because after all, like I told in my previous question that was asked to me, these public servants are supposed to entertain the public. So because I have sent my juniors to the DCP office and to the additional commissioner's office, and they have visited, they have had a sit on with them, and then the FIR has got registered also. So in short, you have to reach their PA or the office before you meet them. They will give you a particular timing. They will tell ki sir 4 baje aate hai, ya sir. So some officers like to meet people in the morning. Some officers like to meet people in the afternoon or in the evening. So like I'm from Navi Mumbai, so the zonal DCP here meets my juniors around between 4 to 6. So we call and confirm it around 3 p.m. and then we go at 4 p.m. and somebody from my office goes and meets the concerned officer. So visiting officers will vary based on the officer you're going to meet. So you'll have to personally inquire or reach out to their number. So Navi Mumbai Police or Mumbai Police has their own website. So in that website, the zonal DCPs or their office number will be given. So you are always at liberty to reach out to that particular number and contact the PA or their office staff and find out that I wish to meet sir in so and so regards. So when are the visiting hours of sir and when can I come in? So that is how you can schedule a meeting with these concerned officers. So you may not be allowed directly to meet the commissioner. So even if you go meet them, mostly his subordinate staff will go and tell you to meet the additional commissioner or the zonal DCP or somebody, and then will tell you if your work does not get done by them, you please come. Then they will meet.
Okay, got it. Thank you, sir.
Sir, actually, my question is some public servant has been booked for like some corruption case under the Prevention of Corruption Act,
Public
Section
servant,
7.
sir, please. I'm so sorry, sir. You were not so
Yeah,
audible.
if
Servant what?
one public servant has been accused in a case
Okay.
under the
Prevention of Corruption
Corruption
Act.
Act
Okay.
under Section 7. So, is there any like time limit that investigating officer or the prosecution of
Unfortunately, sir, apart from rape cases, there is no particular time limit fixed. I mean, under the special statute, sometime there could be a time limit. I have to cross check. But if you see by the provisions of CRPC, the only time limit that is given is of an offense of rape, where the police officer is mandated to file a charge sheet within 60 days. So apart from that, an investigative timeline or limitation is not given to a police officer. And it is also logical if you see, sometimes an investigation is too complex or involves a lot of witnesses. Like I have personally seen cases where when there are 100 or 200 witnesses, for example, in a bomb blast case, or when there is a very terrorism related charge, or anything that has to do with mass corruption involving companies. So the police will have to interview a lot of witnesses. So even if I take, let's say in a week, I interview 3 witnesses, it may take me at least a year to interview a lot of people who are involved in that particular case. This happens mostly in sensational cases or high economic offenses. So prescribing a very tight limit for completing the investigation sometimes will not be in favor of a good investigation. So therefore, there is no time. But of course, CRPC says you are supposed to complete the investigation as fast as possible. That is always there. If it is taking too long, mostly some of the parties who are persons of interest in the case will approach the High Court and ask them to fix a particular time frame if the investigation is unreasonably taking. And of course, there is provision for bail and other aspects of quashing and stuff when it's a false case and it is being unnecessarily dragged for some reason.
So Vinay Swarup is asking, can police be made accused if for not filing FIR? And if yes, then
so
at
there is
what
a provision. I may not be able to recollect the exact provision. So police can be prosecuted for filing a false document or for not doing their inaction. So there is a departmental inquiry aspect also where you can, because the police is subject to their departmental rules. If they do not do their function, for a public servant not performing their duties, there is provision. And if a false FIR is initiated or no FIR is initiated, or if a false paper is filed by the police before the court, there are corresponding provisions in the Indian Penal Code where using those provisions, you can file a private complaint before the concerned court. So yes, police can be made and accused for their inaction.
Sir, I have a question. When you said under DV Act, protection officer can file a FIR. Now, within the police machinery, if a person calls for help under a domestic violence incident, so are there any people, any department which is specifically looking into this, and is there any designated person as a protection officers within
protection
the police?
Officer, sir, and if you're talking about the Domestic Violence Act, there is the protection officer for every jurisdiction, just like a police station. So I think if you just research, I mean, the information of a protection officer can be available in the police station, or you can actually reach out to even if you Google or you reach out to the authority, domestic violence protection officer, you can find online. So there is basically a list and a schedule of all the protection officers.
That list I saw, but I just wanted to know that within the police machinery also, if there is anybody, or even they say service providers who are there.
So here, if a lady, let us say if a lady approaches the police station for domestic violence, the police are duty bound to refer her to a protection officer if she wants to proceed under the Domestic Violence Act. So like I told you, so there are 2 ways a domestic violence victim can proceed. So that is under the Dowry Prohibition Act, and that section is included under the 498A. That is, you set the criminal law in motion through an FIR, or you go to the court and file a DV application. Now, to file a DV application, the lady can go to the protection officer also. So the protection officer can file in one of my matters, which has come before me recently in the year 2016. We won that case also. So in 2016, the case was filed on behalf of my client by the protection officer. So the protection officer filed a case on behalf of her. It was not a 498A case through an FIR, but it was a case it was a domestic violence application before the magistrate directly filed by the protection officer. So when you approach a police station, if suppose you want to go to the Domestic Violence Act way, then they will refer the lady to the protection officer. Otherwise, if they say an FIR has to be registered, they themselves can take the FIR and a lady officer can take your FIRs.
So in a domestic incident where a lady is involved, if the police is not taking action, DCP is not taking action, so you had recommended a higher authority as Human Rights Commission.
Yeah,
So,
Human Rights Commission or Police Complaint Authorities.
Police Commission. So is there another channel for Women's Commission? Any other specific organization?
Yeah, so if it's a woman can approach the Women's Commission, but the Women's Commission will also call for the proceeding. Yes, and there is, for example, somebody who's from an SC/ST schedule under the Constitution, they can approach the SC/ST Commission also. So those special commissions are always there. You can approach the concerned department through those special commissions also. So they are also empowered to call and seek a report from the concerned police station. Then there is National Human Rights Commission. So there are multiple aspects.
Women's Human Rights, Women's Commission, it would be a better list.
Yes, so, if it is a DV case, sir, I would recommend that. The lady can approach the Women's Commission. Yes.
So now coming back to an earlier question which came up about 182 and 211.
Okay.
The police does not, in case, even if they file a B summary, they don't register a case against, or they don't even recommend 182, 211. So in a discussion with somebody, a point came up that why they don't put 182, 211, because if the magistrate who is supposed to finalize the B summary, as it is, B summaries are taking more than a couple of years, 4 years, 5 years, they are not being closed. The magistrate has to become a witness in filing a case for the 182 and 211. Is this correct? So that is why then
are you asking me whether the magistrate should take cognizance if the police does not do of 182 and 211?
Well, police normally will have to, the procedure what I was made to understand was the police will recommend 182, 211 along with the B summary. And then the magistrate, once he closes B summary, he says, yes, this is a B summary. Then he becomes a witness for 182, 211, which they don't want to do. So that is why the police is also not filing this. So is this correct?
Yeah. So that is also there. That is one aspect. That aspect comes, sir, when the police recommends to the magistrate that it's a B summary and no action should be, and action under 182 or 211. But the point is, just like I told you how the police does not want to set a precedent by taking action against the wrongful complainant, similarly, the courts are also in a reluctant attitude. I'll just tell you very frankly, even if, let's just say, during cross-examination, if some witness lies on the stand, you might have seen in movies how judges take action for lying to the court. But hardly there is any punitive measure taken against witnesses who lie. Of course, it affects a substantial case in which they lied, but no action is taken against them. I have practical view of the same. Some judges, if they really are good, may initiate some action. Even when it comes to contempt, the power to punish for contempt is with the High Court. So some judges also, if the lawyers also misbehave or something, they try to contain the situation. So it is all because of the documentation process and the overload of cases that the police and the courts have, that most of these things go unanswered. And people are not so keen on initiating action for minor stuff. So they let it go. They leave it to the complainant or the victim to challenge this particular. Or unless it is too grave, they don't initiate. So you are right, sir. But again, that also happens at a very later stage and very hardly it takes place. Mostly nothing happens to that once the report is filed. Everybody just forgets about it. And even the complainant or the accused, who is actually the affected party because of that, he is also told to let it all go. Because then he will think, oh, the investigation and the entire process was a traumatic one. Now I am at a stage where at least the proceedings are closed against me. I do not want to again get into this police and court business. So they also let it go. And these are a few of my personal experiences also. Though the clients have gone through a lot, even somebody who has jailed, they don't want to take action against the complainant because it sets an again 1-2 year dilemma where they'll have to go through court or the police. So it's just quite unfortunate.
Pradeep sir is asking, what is the remedy if deliberately police files FIR for lighter crimes?
Oh, so then the best remedy, I would say, the lighter crimes, as in, sir, you need to give me a clarification, a crime which has happened or which has not happened. Are you telling it's a false FIR or an FIR which has some merit but not serious? Accordingly, I'll answer that question.
Sir, if the police files a FIR for serious crimes under lighter sections, and how to handle such situations?
Oh, okay, I understood. So basically, you are saying that the police just scale down the veracity of the crime by putting minor sections. If let's just say it was a grievous hurt where the hand was cut, and the police will put a provision of just hurt, a minor hurt. That's what you would say, right?
Right, sir.
So, sir, in this particular case, now whenever an FIR is registered and the investigation happens, there is a stage called charge framing. Now, this process of charge framing takes place before the court, before the judge. So, in case if you feel that though the witness statements and the materials gathered during the investigation reveal a serious offense, which is greater than the sections that is involved in the case, you very well can tell the judge through the public prosecutor, if you are the informant, that sir, so and so sections, no, it should be so and so sections. So if you move an application through the public prosecutor, the judge, before proceeding to trial, at this stage of charge framing, once he receives the charge sheet, he can frame charges under a different section. So whatever the section the police have used, it is immaterial because the judge has the final discretion to proceed the trial under whatever section he deems fit. So there is always a discretion that the court has. And so your duty is just to inform the court how the sections that you claim to be attracted are invited in the said case. So once you make an application to that effect, that can be taken. Second, you always can write to the concerned senior police inspector or the investigating officer that the FIR, that the sections lodged in the FIR are not the serious ones. So you wish that the police officer will carry out necessary changes in the FIR. So he can do so with the permission of the magistrate. So he just needs to obtain a routine permission from the magistrate that so and so sections have been wrongly added by me, or I wish to add more sections upon the investigation that has taken. So if the magistrate permits, which is always the case, he will permit, the sections are added. Mostly police officers are a bit lazy at the initial stage to add those sections. But if they do a good investigation and you feel those sections are inefficient, you can always tell the magistrate to amend the sections and put the higher charges.
Thank you so much, Vinay, for such an illuminating webinar.
Thank you.
Can't thank you enough, and hope to see you soon with yet
Definitely,
another.
definitely. Always happy to be associated with PLEA. Welcome. Thank you so much.